The week my younger brother took a sledgehammer to the wall I had spent 14 months building, he filmed it on his phone, posted it to Instagram, and tagged our mother in the caption. I was at a closing appointment when it happened. I had driven 40 minutes to sit across from a title agent and sign my name 11 times on documents I had reviewed 3 times the week before, because that is the kind of person I am about paperwork. The property was a duplex on Callaway Street in Maplewood, a 2-unit rental I had been watching for 8 months, a listing that had gone stale twice before I made my offer. I was 31 years old. I had been working as a contracts coordinator for a commercial insurance firm for 6 years. I had a savings rate that my coworkers thought was either admirable or depressing depending on who you asked. I had no co-signers. I had no help. I had $54,000 in a high-yield savings account that I had built by making a specific series of choices for 4 consecutive years, and when the title agent said congratulations and slid the keys across the table, I sat with them in my palm for a moment before I put them in my pocket. My brother Colton had never owned anything. That is not entirely fair. He had owned a motorcycle for 6 months before he totaled it. He had owned a food truck concept that our parents funded to the tune of $38,000 and that lasted 11 months before he decided the hours were incompatible with his lifestyle. He had owned, briefly, a share in a friend's landscaping company that dissolved when the friend moved to Phoenix, and Colton did not follow through on the paperwork to buy him out. What he had never owned was real estate, or a savings account with more than 4 figures in it, or the particular feeling of signing your name on something that is entirely, provably, legally yours. I had tried not to keep score. I want to be honest about that. Keeping score in families is corrosive and I knew it. But the numbers existed whether I tracked them or not. My parents, Frank and Diane, had co-signed Colton's first apartment lease when he was 24, then his second, when the landlord of the first one declined to renew. They had absorbed $14,000 of his credit card debt in a lump settlement the year he turned 27. They had funded the food truck. They had paid 3 months of his insurance premiums after his license was suspended following a DUI. They had given him $9,000 toward what was described to me as a fresh start, though the specifics of what that start involved were never made entirely clear to me. I had received from my parents a $200 Amazon gift card when I passed my insurance licensing exam, and a card that said they were proud of me. I kept the card. I used the gift card on office supplies. I want to be precise about this, not because I am bitter, though I understand if it reads that way, but because the numbers matter later. The numbers are the entire point. When I bought the Callaway Street duplex, I told my parents about it the Sunday before closing. My mother said that was exciting. My father asked if I was sure I wanted to be a landlord because tenants could be difficult. Colton, who was at that dinner, said nothing. He was looking at his phone. He looked at his phone through most of dinner that night, and then he left early, and I remember thinking that was fine. I had learned not to need things from Colton. What I did not know, sitting at that dinner table with my keys still in my jacket pocket, was that Colton had driven past the duplex the previous week. He had not told me this. He had not told me that he had looked up the listing. It was still findable online, and seen the address, and decided to take a drive. I found this out later, from a text message chain I was not supposed to see, and I want to be careful not to get ahead of myself. The duplex on Callaway Street had been vacant for 4 months before I bought it. The previous owner was an estate. An elderly woman named Mrs. Thibodeau had died the prior spring, and her adult children, who lived out of state, had accepted the first reasonable offer. The lower unit had some cosmetic damage. Water staining on the ceiling from a slow roof leak that had since been repaired, a kitchen floor that needed new vinyl, one bathroom with a cracked vanity mirror and fixtures from 1987. The upper unit was in decent shape. I had budgeted $22,000 for renovations and I intended to do a portion of the work myself. I am not a contractor. I want to be clear about that. I am a contracts coordinator who owns a good set of tools, has watched a significant number of YouTube tutorials, and is not afraid of a weekend. I stripped the lower unit kitchen floor myself over 2 consecutive Saturdays. I replaced the vanity and fixtures in the lower bathroom myself, using a plumber only for the final hookups, because I know the line between what I can learn and what requires a license. I sourced tile from a salvage company 2 towns over. I painted both units. I installed new blinds and door hardware and replaced the ceiling fans throughout. My contractor handled the drywall repair in the upper unit hallway, the exterior trim, and a section of subflooring in the lower bedroom that had more rot than the inspection had suggested. His name was Paolo, and he had done work for my firm's property clients before, which is how I found him. He was reliable and he charged me fairly, and when the lower unit was ready, he walked through it with me and said I had done good work. The lower unit tenant's name was Cheryl. She had 2 school-age kids, a calm voice on the phone, and a rental history that went back 8 years without a single late payment. She signed a 12-month lease on a Wednesday afternoon, and I handed her the keys in the living room I had repainted the previous month in a color called warm linen that had taken me 3 samples to land on. The upper unit I kept vacant for the first few months while I finished the repairs. The spare key to the lower unit, Cheryl's unit, lived on a labeled hook inside my parents' house. I had asked my mother to hold it. She was 15 minutes from the property and I was 40, and I had thought at the time that this was what family was for. This is the part I return to most when I try to understand what I was thinking. I had believed, specifically and without examining the belief very carefully, that my family could be trusted with the ordinary logistics of my life: a spare key, a phone number, the kind of small, practical dependence that does not require trust so much as basic decency. Colton knew the key was there. He had been at the house when I asked my mother to hold it, had heard me describe which hook and which label. I know this because my mother told me later, after everything had already happened and there was no reason left to protect anyone. The renovation on the upper unit was nearly complete. I had 1 weekend left of work: trim painting, a light fixture swap, cleaning, and then I was going to list it. I had run the numbers on the rent I needed to cover my mortgage and expenses, and I was within range. I had a spreadsheet. I had a plan. Colton came to the duplex on a Tuesday morning. I was at work. Cheryl was at work. Her kids were at school. He had taken the spare key from my parents' house that morning. My mother later said she had been in the shower and did not hear him come in, which is a sentence I have thought about a number of times since. He entered the lower unit. Then he went to the upper unit through the shared interior stairwell, which I had not yet rekeyed separately because I had not finished the renovation and had not listed it and had not thought anyone had a reason to be there. What he did in the upper unit took approximately 25 minutes based on the timestamps on his phone. He filmed himself breaking the new drywall in the hallway with a claw hammer he had brought in a duffel bag. He filmed himself pulling the new light fixture out of the ceiling junction box, not carefully, the way an electrician would, but by grabbing the fixture and yanking until the wires pulled free. He filmed himself putting a hole through the interior of the closet door with his foot. He did not touch Cheryl's unit. I have tried to understand the logic of that, and I think the logic is that Colton, whatever else he was not stupid enough to do something that had a queer victim other than me. He posted the video to Instagram at 11:43 in the morning. The caption said, "This is what happens when you think you're better than everyone." He tagged our mother. I found out because Paolo called me. Paolo had driven by to drop off an invoice and had seen the front door not fully latched. He had gone in to check and then he had called me, and his voice had the specific quality of someone who has already assessed damage and is choosing their words with care. I stepped out of a meeting and stood in the hallway of my office building, and he told me what he was looking at. I asked him not to touch anything. I called the non-emergency police line from my car in the parking garage, and then I called my attorney. Her name was Sandra, and I had found her through a former colleague who had used her in a commercial landlord dispute. She was not a close contact. She was competent and direct, and when I told her what had happened, she asked me 2 questions. Did I have the lease on the lower unit, and had I reviewed my own purchase agreement recently? I told her I had both documents. She said send them tonight, along with whatever photos you can take before you leave the property. Then she asked who held the spare key. I told her my parents did. She said call me after you've seen the property. Don't talk to your brother or your parents until we've spoken. The damage assessment came in 10 days later. The total was $19,400. That number covered the drywall repair, the ceiling junction box and rewiring, the closet door, and, because the wiring had been improperly pulled and Paolo identified a scorched connection that needed full inspection, an electrician's safety review of the upper unit that found 2 additional connections compromised. $19,400. The upper unit would not be listable for at least 6 more weeks. Cheryl had seen the Instagram video. She called me the night it posted. Her voice was careful in a way that told me she was deciding whether to stay or start looking. I told her the lower unit had not been touched, that I was handling the situation, that her lease was secure. She said she appreciated me telling her. She did not say she was staying. Sandra had read my lease by the following morning. There is a clause in my purchase agreement, not the lease, the purchase agreement, the document I signed when I bought the property, that I want to explain carefully because it is the clause that changed everything. When I bought the duplex, I negotiated language with the seller's estate attorney around third-party access liability. The estate had concerns about residual access from the prior owner's arrangements, a neighbor who had held the key for decades, a lawn service that had a gate code, and I had wanted those concerns formalized and closed. My attorney at the time had drafted a provision that established clear liability for any party who granted access to the property, expressly or implicitly, to a person who subsequently caused damage. The language was broad. My attorney had told me it was broad. My attorney had told me it was broad. I had told her I wanted it broad. The spare key had come from my parents' house. My parents had received that key from me. Their holding of the key constituted, under the language of that clause as Sandra read it, implicit authorization of access. The fact that Colton had taken the key without their explicit knowledge did not fully sever the chain. Sandra said the language on third-party custody of access materials was specific enough that their holding of the key made them a liable party alongside Colton. I asked her what that meant in practical terms. She said it meant the claim could be filed against Colton and against my parents jointly. My father had a home equity line of credit on their house on Aldermore Drive. He had opened it 3 years earlier. The outstanding balance was significant. I did not know the number at the time, but I knew the line existed because he had mentioned it once in passing when discussing Colton's food truck funding, had mentioned it in a way that suggested it was one of the sources. What Sandra discovered, in the course of researching my parents' financials as they related to the claim, was that the HELOC carried a standard covenant that my parents' lender, a regional bank called Cornerstone Lending, enforced on any active civil liability claim exceeding $15,000 filed against the primary borrowers. The threshold triggered a mandatory account review. My claim was $19,400. Sandra filed against Colton and against my parents as joint liable parties on a Thursday. Cornerstone Lending received notification of the filed claim within 5 business days as required by the covenant terms. My father called me on a Saturday morning. He was not calm. He told me I was punishing the entire family for something Colton had done. I told him I was recovering the cost of damage done to my property using the legal tools available to me. He said the claim against them was not fair, that they had not given Colton the key. I told him they had held the key. There is a difference, he said. I understand that you believe that, I told him. My mother called that same afternoon. She did not ask me to drop the claim. She asked me how I could do this to them. I told her I had not done anything to them. I told her Colton had come to my property with a bag of tools and a camera and had destroyed work I had spent months doing and that the spare key he used had lived in their house. She said Colton was going through a hard time. I said, a lot of people go through hard times and do not bring a claw hammer to their sister's rental property. She started to cry. I stayed on the line until she was done, and then I told her I loved her and that I was not dropping the claim. Colton called me once. He did not apologize. He said the video had been a mistake and that he had deleted it. I told him deleting it did not delete the timestamps the police had already pulled, or the screenshots 17 people had taken before he took it down, or the statement Paulo had given to the responding officer, or the damage assessment sitting in Sandra's filing system. He said I was making this a bigger deal than it needed to be. I told him I was making it exactly the size it actually was. Cornerstone Lending completed their account review in 19 days. The HELOC on Aldermore Drive was not called. That required a final judgment, not a filed claim. But the bank required my parents to either reduce the outstanding balance by $22,000 within 60 days or accept a renegotiation of the line at a substantially higher rate. My parents did not have $22,000 liquid. They had been drawing on the line for years. They had, at various points, drawn on it for Colton. The settlement was reached before trial. Colton's share of the liability was structured as a payment plan. My parents, as joint parties, signed a personal guarantee that bound them to the balance if Colton defaulted, which Sandra had advised me was a likely scenario, based on Colton's documented financial history. The total settlement was $18,750, which reflected a small reduction from the full assessment in exchange for a signed admission of liability and a no-contact provision regarding my property. The criminal side moved on its own timeline. The responding officer had filed a report. The video, time-stamped and with Colton's face clearly visible for portions of it, was part of the evidentiary file. The charge was criminal mischief in the second degree, which under our state statutes covered intentional damage to property between $1,500 and $3,000 in a single count, with the total damage aggregated across multiple counts. His attorney negotiated a plea. Colton received 18 months of probation and 200 hours of community service. I want to be clear about how I feel about that sentence, because people asked me and I gave them an answer I believe is accurate. It was not enough. What he received would not have been enough even if the property damage had been half what it was. The community service hours were not enough. The probation was not enough. What he did was not a mistake in the sense that mistakes are made. It was a decision made with preparation, documented on camera, posted publicly, and captioned with language that made his intention explicit. The legal system made a determination about proportionality, and I disagree with that determination, and I have accepted that I cannot change it. What I can tell you is that I rekeyed both units the day after the damage assessment. I changed the protocol for spare keys. I have one at my own home and one with Paulo, who I trust for exactly the professional reasons that make trust reasonable. I listed the upper unit 6 weeks after the settlement was reached. The tenant who moved in, a graduate student named Will who works remotely and plays acoustic guitar, which Cheryl confirmed she did not mind, has been quiet and on time for every payment. The Callaway Street duplex cash flows within $80 of my original projection. Cheryl stayed. She renewed her lease. My parents have not paid off the HELOC. They are paying it down on the renegotiated terms, which costs them more each month than the original arrangement. My father has not said to me directly that he understands why I did not drop the claim. My mother calls on Sundays and we talk about other things. I do not know what Colton is doing. He has not contacted me. The no-contact provision runs for 2 years from the date of the settlement, and I have saved a copy of it in the same folder where I keep the original purchase agreement and the lease and the damage assessment, and every document that belongs to the property that is, legally and entirely, mine. I built something. Someone tried to take it apart on camera and post it online. The camera was the mistake he did not know he was making. The spare key was the thread Sandra pulled. The clause was the wall that held. I am not a person who celebrates other people's consequences. I want to say that clearly. But I am a person who spent years doing the work quietly, without asking for what my brother received without asking, and I am a person who, when it became necessary, knew exactly which documents to send, and which attorney to call, and which clause in which agreement said what I needed it to say. That is not luck. That is what it looks like when someone has been paying attention for a very long time. I have thought a lot about the word mistake since all of this happened. Colton used it. His attorney used it. My mother used a softer version of it. She called it a lapse, which is the word people reach for when mistake feels too accountable. None of those words fit what I watched on a video time-stamped 11:43 on a Tuesday morning. A mistake is when you say the wrong thing in a meeting or you forget to return a call. What Colton did required a bag, a drive across town, a key he had to retrieve from someone else's house, and a decision to press record before he started. That is not a lapse. That is a sequence of choices, each one requiring the next one, each one executable only if you have already decided the person on the other end of those choices does not fully matter. I think about that a lot, actually. Not with anger anymore, mostly with something closer to clarity. The choices we make when we believe no one is watching or when we believe the consequences will be absorbed by someone else are the most honest version of our character. Colton believed he would not face anything real. He had learned that from years of evidence. Every time my parents stepped in, the lease cosigns, the credit card settlement, the food truck money, the insurance premiums, they were teaching him something. They meant to teach him that family shows up. What they actually taught him was that his choices had no terminal point, that someone would always be at the bottom to catch whatever he dropped. What I had spent years learning was something different. I had learned that the document you read carefully at the beginning is the thing that protects you at the end. That the clause you negotiate when nothing is wrong is the clause that matters when everything goes sideways. That trusting people is reasonable, but trusting them with the logistics of something you built entirely on your own requires a different kind of examination than I had given it. I gave my parents a spare key because I believed that was what family was for. I was not wrong to want that to be true. I was just not careful enough about whether it actually was. Sandra pulled the thread. The clause held. Those two things happened because I had done the work ahead of time, not because I was lucky, not because I was ruthless, but because I had paid attention and made decisions I could document and stand behind. That is what I want anyone listening to take from this, if they take anything. Not that you should distrust your family, not that you should build walls and hold everything alone, but that preparation is its own form of integrity, that knowing your own documents, understanding your own agreements, and being willing to enforce them when you have to, those are not cold or calculating things. They are the evidence that you took what you built seriously enough to protect it. Cheryl renewed her lease. The upper unit has a quiet tenant who pays on time. The duplex is mine, fully, cleanly, with paperwork that says so in language I helped write. Colton has 200 hours of community service and a probation officer and a settlement that follows my parents for the next several years. I did not build this outcome. I built the property, and I built the protections, and then I let each thing do what it was designed to do. That is the whole of it. You do not have to be harder than the situation. You just have to have done the work before the situation arrived.